appeal in the matter of the Lord Chancellor and MTA and another.
Yes, Mr. Appellant.
My Lord, I appear for the Lord Chancellor in this matter, together with Mr. Ricardo Calzavara. The Lord Chancellor is the applicant in the strikeout application and the second defendant to the Part 7 claim. Mr. Martin Westgate, King's Counsel, appears for MTA, the respondent in this appeal, together with Mr. Daniel Clark. And Mr. MTA is, of course, the claimant in the Part 7 claim. The first defendant to the Part 7 claim, the Metropolitan Police, did not play any part in the strikeout application and play no part in the appeal today. My Lord, just a matter of housekeeping to check what bundles your Lordships have.
Yes.
I hope you have a core bundle, a supplementary bundle, and a joint authorities bundle.
We do.
We are working electronically. I see your Lordships have hard copies, but I hope, for once, that the pagination matches and that the bundles are in a single volume.
So do we, Mr. Clement. I'm sure we'll cope even if they don't.
Thank you, my Lord. My Lord, the central issue on this appeal is whether it is an abuse of process for a claimant to bring a Part 7 claim for damages arising out of a judicial act under Section 9(1)(c) of the Human Rights Act without first seeking to appeal the judicial order in question. We say that this question raises an important point of statutory interpretation of the Human Rights Act itself, and that it necessarily involves the consideration of fundamental constitutional principles. Our primary submission is that it is an abuse of process, and it will be an abuse in all cases where the order can be and ought to have been appealed. We say the judge was wrong to conclude otherwise.
So in all cases where the order can be or ought to have been and ought to have been
appealed. My Lord, that is the language. I'll show your Lordship in a moment. That is
That's the language of Maza.
And my Lord, since...
When you say where the order can be appealed, at what point in time are you asking that question?
Well, my Lord, at any point after the order has been made.
Well, there's a time limit, usually, for bringing an appeal.
Yes. And we say the time limits are an important point that Parliament would have been aware of in enacting the Human Rights Act and Section 9 in the
If time has expired for an appeal, is that an order that still can be appealed?
Well, my Lord, it can be appealed with an extension of time from the appellate court. My Lord, as a result of the judgment under appeal, a number of Part 7 claims have been brought against the Lord Chancellor in respect of judicial orders that have never been appealed. And there are a number of those matters that are currently stayed or on hold pending the outcome of this case. And my Lord, to be clear, our fallback position, as it was before the judge, is that if no such blanket rule exists, then it is an abuse in this particular case, and the judge was wrong to conclude that it was not. In terms of how I intend to structure my submission, I'm going to start with two preliminary points. Second, I'm going to take your Lordships to key provisions in the statutory framework. Third, I'm going to take your Lordships to key conclusions from this court's judgment in Maza number 1, as well as showing your Lordship the first instance judgment in Maza number 1 to show how the Court of Appeal reached the conclusions it did. Fourth, I'm going to make submissions on what we say is the nature of the abusive process in this case. And then finally, I turn to our grounds of appeal and will address why we say there is a blanket rule and address our fallback submission. So, my Lords, turning to my two preliminary points. My first preliminary point is that the Lord Chancellor is not seeking to prevent this claimant from challenging the judicial orders in question. What the strikeout application was about, and what this appeal is about, is the correct interpretation of Section 9(1) of the Human Rights Act and whether it is an abuse to pursue Part 7 claims for damages without even attempting to appeal the judicial orders. My Lord, the Lord Chancellor has always accepted that the Maza route remains open to the claimant, namely to pursue an application for permission to appeal out of time, and we would not oppose an application for an extension of time, given the confusion that has arisen about the appropriate route to challenge these orders. That was the Lord Chancellor's position in Maza. That would be our position here.
But it would be the, sorry to interrupt, it would be the landlord that would have to make the decision, wouldn't it, about whether to oppose the extension of time?
My Lord, if the landlord wished to play a part in the appeal, they could, of course, make those submissions. In Maza, I think permission, I'm just thinking back, permission to appeal was granted without cheering from the NHS Trust. My Lord, we then say if the appellate courts determined that the judicial orders breached the claimant's convention rights, then it would not be an abuse to bring a Part 7 claim for damages. And in those circumstances, the Lord Chancellor would be able to settle any claim without infringing the independence of the judiciary.
So sorry, I just missed the beginning of that. In what circumstances?
If the appellate...
Oh, we're still on the first preliminary point.
The first preliminary point, we don't oppose...
Yeah. Well, we're still on the first preliminary point.
Exactly,
We
don't
second.
oppose
Yep.
a challenge. If this were brought by way of an application for permission to appeal out of time, then, once the appellate court has determined whether there is a breach of the convention rights, it wouldn't be an abuse to bring a Part 7 claim for damages.
If you have an order made by district judge, the appeal would be to circuit judge?
The appeal would be to circuit judge, my Lord, yes.
And would the circuit judge have power to find a breach of Article 5?
Yes, my Lord. It would be on the basis that there's an error of law. What is the error of law? I'll show your Lordship in a moment Section 6 of the Human Rights Act.
Right.
And how that relates.
And the decision of a circuit judge on appeal would be good enough for the Lord Chancellor?
Yes. My Lord...
Hang on 1 second. Can we just... Suppose there were an appeal out of time. The circuit judge would have to decide whether the order was lawfully made. We'd have to decide whatever the grounds of appeal were. I'll go back to that. We'd have to decide ultimately simply whether to quash the order. Would it be open to the circuit judge to say this order was made at a time when it appears that the claimant was a protected person and did not have a litigation friend, and therefore the order falls to be quashed by reference to I can't remember what, Part 20, whatever the rule
Yes,
is,
21.34, my Lord, yes.
and simply not mention human rights at all.
That's a possibility, my Lord. But at least in that situation, you would have an appellate determination as to whether that order, the judicial order, was lawful or not.
I see that, and I just wanted to. We talked rather glibly about deciding the Court of Appeal, the appellate court, as were deciding the human rights point. They wouldn't necessarily decide the human rights point. They would simply have to decide whether the order should stand.
Well,
and they needn't take an Article 5 route to that at all.
They needn't, my Lord. In Maza, they obviously did. If there were to be permission to appeal on the basis that, as a preliminary step to finding a claim for damages, then one of the grounds of appeal would obviously be that this judicial order breaches a claimant's Article 5.
You say it would obviously be. Why would it obviously be?
Because if one wants to find a claim for damages, one can only find a claim for damages based on a breach of Article 5 or Article 6 of the Convention as it relates
But that could be decided by the court in the damages claim which followed on once the order had been quashed on appeal. The logic of the position I think you put to me, your original answer, was the real obstacle is the existence of an order which renders the act complained of lawful. If that order is quashed for any reason, that obstacle goes, and human rights questions can be, and arguably would more conveniently be, decided in the subsequent proceedings.
Well, my lord, we don't dispute that they could be, because that is the process that was adopted in LL and Lord Chancellor, which was endorsed by the Court of Appeal in Mazhar. But if the claimant's complaint is I was detained in an unlawful, pursuant to an unlawful order, the grounds of appeal would, in my submission, almost inevitably include a breach, an alleged breach of Article 5 and or Article 6.
I dare say they would as a matter of reality. I'm just trying to get the analysis right. All that matters, from the point of view of your submission, is that the order should be quashed. That removes the problem of inconsistent orders, effectively.
Yes.
It doesn't have, the grounds on which it's quashed are logically irrelevant. There might be some cases where the only possible challenge to the order would be a breach of Article 5, but that wouldn't always be the case, and this case seems to illustrate that quite neatly.
It won't always be the case, my lord, but if one is considering a claim, if one is saying I am detained pursuant to an order of the court when I should not have been, and it is only the detention cases that we are concerned with, because those are the only cases that found a claim for damages arising out of a judicial act, it is inevitable that one is going to be arguing that there is a breach of Article 5 of the Convention. Now, I don't say as a matter of my analysis that has to be...
So why do you say inevitable? I don't want to go on about this, but I still haven't quite understood. Why is it inevitable?
Because if one wishes found a claim for damages under Section 9 of the Human Rights Act, it has to be based on a breach of Article 5.
Oh, yes, but you could do that. My point is you could do that in the subsequent proceedings. Perhaps I misunderstood what you were saying.
So, my lord, my primary position would be that the appellate court is itself determining whether there is a breach of Article 5. Why? Because the court is a public authority under Section 6. I'll show your lordship the statutory provisions in a moment. And the court is under a duty to act compatibly with.
But it would do that if it quashed the order. The reason I'm making a fuss about this is not just to be accurate, though that's important in itself, but because it seems to me that in some cases, and this may not be a good example of them, in some cases there will be complicated fact-finding that requires to be done to decide whether there's a breach of Article 5. And that might well be more appropriate to be done not in an appellate context. Now, sometimes I accept if the only available ground is that the order was made in breach of Article 5, and in order to make that good, you may have to adduce evidence, and the appellate court will have to entertain the evidence. But in other cases, of which this might be an example, there's a straightforward route to quashing the order, and you leave all the fact-finding to be done second time round.
My lord, both of those could work,
Yeah.
but my primary submission, as I said, is that the appellate court will itself determine whether there's been a breach of convention rights, the Maza approach. The ground of appeal is this order, well, there are a number of grounds of appeal, but one of those grounds is, and this judicial order breached Article 5 and Article 6. The other approach that was endorsed by this court in Maza was LL and Lord Chancellor, where the Court of Appeal quashed or allowed the appeal, and my lord, one doesn't have to necessarily quash the order. It's a judicial finding that the order was unlawful. That's the key element here. It's It's not the Lord Chancellor deciding whether the judicial order was unlawful. It's the court that determines whether the initial judicial order was unlawful.
Is there any distinction between deciding that the original order was unlawful and deciding that the original order was wrong?
My lord, I think if it's wrong, then it is unlawful. I wouldn't draw a distinction in that way. If it's wrong, there's an error of law in the approach that the judge took, therefore it's unlawful.
For some purposes, that makes sense. I mean, unlawful is a slippery word. It can mean different things in different contexts. Anyway.
My lord, that was my first preliminary point. My second is that this is not what was termed below a barren procedural dispute generating satellite litigation, nor is it, we say, a case management issue. It is an important point of statutory construction of the Human Rights Act. It is an important point applying the guidance given by this court in Maza, asking what does that guidance mean. And it does require, in our submission, a careful consideration of the doctrine of separation of powers and the principle of the independence of the judiciary. So, my lords, if I can move to take your lordship through the statutory framework, if I could ask your lordship to pick up the authorities bundle and tab 2, which is, I don't know if your lordships have tabs, but this is page 6. Starting point is section 6 of the Human Rights Act, and section 6.1, it is unlawful for a public authority to act in a way which is incompatible with a convention right. And section 6.3, in this section, a public authority includes a court or tribunal. So the court itself is a public authority, and it is unlawful for the court to act in a way which is incompatible with a convention right. Section 7 is at page 7. This is the general way in which proceedings are brought under the Human Rights Act. Section 7.1, a person who claims that a public authority, which would include a court or tribunal, has acted or proposes to act in a way which is made unlawful by section 6.1, may bring proceedings against the authority under this act in an appropriate court or tribunal, or rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. Subsection 2 defines appropriate court or tribunal as determined in accordance with the rules. And then subsection 5 has the time limit. Proceedings under subsection 1A must be brought before the end of the period of 1 year, beginning with the date on which the act complained of took place, or such longer period as the court or tribunal considers equitable in regard to all circumstances, subject to any rule imposing a stricter time limit in relation to the procedure in question. My lord, one then has the definition of rules in subsection 9, which is rules made by the Lord Chancellor or Secretary of State for the purpose of this section of rules of court, that is the CPR.
Well, rules of court are CPR.
Yes.
But there could be rules made either by the Lord Chancellor or the Secretary of State which are not the CPR.
Yes. But my lord, I accept that.
So there is a rule-making. If the Lord Chancellor is particularly bothered by what's going on, there is a rule-making power which could cut down the number of cases brought without, for instance, appealing, provided that those rules don't impair the very essence of the right.
Yes, my lord, I accept that. And indeed, in Scotland, there is a rule to that effect, which I'll show your lordship when I turn to Maza. My lord, in terms of section 8, these are the judicial remedies. Again, these apply in the normal claims that are brought under the Human Rights Act. In relation to section 8.1, in relation to any act of a public authority which the court finds is or would be unlawful, it may grant such relief or remedy or make such order within its powers as it considers just and appropriate. But subsection 2, damages may be awarded only by a court which has power to award damages or to order the payment of compensation in civil proceedings. And subsection 3, no award of damages is to be made unless the court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it is made. So in other words, that's tied to, as subsection 4 shows, the principles applied by Strasbourg in relation to the award of compensation under Article 41 of the Convention. My Lord, that is the ordinary way in which claims are pursued, but we have specific provision under the Human Rights Act for judicial acts, which is found in section 9 at page 10. And this section limits the claims that can be made under section 7.1a, which arise out of judicial acts. So proceedings under section 7.1a in respect of a judicial act may be brought only A, by exercising a right of appeal, B, on an application or in Scotland a petition for judicial review, or C, in such other forum as may be prescribed by rules. That doesn't affect the normal rules about judicial review, so the High Court can't be subject to judicial review, for instance. And then we have subsection 3, and I'll show your Lordship shortly how that provision was originally enacted and also how it was originally introduced in the bill to Parliament. But as currently formulated, subsection 3 states that in proceedings under this Act in respect of a judicial act done in good faith, damages may not be awarded otherwise than A, to compensate a person to the extent required by Article 55 of the Convention, or, and the new addition, to compensate a person for a judicial act that is incompatible with Article 6 of the Convention in circumstances where the person is detained, but for the incompatibility, the person would not have been detained or would not have been detained for so long. So it's essentially to give effect to Article 5.5, and the addition in B is to reflect the judgment of the Strasbourg Court in Hamilton and United Kingdom. So that was added by way of a remedial order. My Lord, the definition then in, or rather section 9.5 provides that an award for damages permitted by subsection 3 is to be made against the Crown, and no award may be made unless the appropriate person, if not a party to the proceedings, is joined. And then subsection 5, the appropriate person means the minister responsible for the court concerned or a person or government department nominated by him. And the appropriate person in respect of all civil courts, as opposed to courts martial, is the Lord Chancellor. My Lord, over the
This may not matter, but in the case of a tribunal, is the appropriate person the Lord Chancellor, or
Yes.
is it, even if it's one of those tribunals that's still maintained by the DWP?
Yes, my Lord, the only
There's no
provision...
DTI. Maybe there aren't any.
I don't think there are any, my Lord.
Okay.
Competition Appeal Tribunal.
Is maintained by DTI.
Well, it's outside the tribunal's provisions. It's separately funded.
Well, the provision that's made by order, we find the rule in 19.5 of the CPR, which the only derogation from it being the Lord Chancellor is if the judicial act is that of a court martial, and the appropriate person then is the Secretary of State for Defence.
So the legislator, and it doesn't matter in this case, but the legislator seems to have assumed it's
the
Lord Chancellor or Secretary, even
Yes.
for tribunals.
Yes.
Well,
My Lord, my learned friend makes a point that the submissions I make wouldn't apply to the Secretary of State for Defence. I'll come on to that in a moment. But as a matter of practice, those instructing me have made inquiries, and the Government Legal Department is not aware of any claims that have been brought against the Secretary of State for Defence under Section 9 of the Human Rights Act. My Lord, over the page one has the Convention rights themselves, page 12. And if one turns to page 13, one has Article 5 and Article 6. And Article 5, everyone has the right to liberty and security of the person. No one should be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. A is the lawful detention of a person after conviction. That's not relevant, but B is relevant here. The lawful arrest or detention of a person for non-compliance with the lawful order of a court or in order to secure the fulfilment of any obligation prescribed by law. then, my Lord, Article 6 is well known. In the determination of his civil rights and obligations, everyone is entitled to fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. My Lord, the next statutory provision is at tab 3 in the Constitutional Reform Act 2005. Which starts at page 16. And my Lord, we have at section 1, heading the rule of law, the Act does not adversely affect the existing constitutional principle of the rule of law, or B, the Lord Chancellor's existing constitutional role in relation to that principle. Over the page we have at section 3, the guarantee of continued judicial independence. And subsection 1, the Lord Chancellor, other ministers of the Crown, and all with responsibility for matters relating to the judiciary or otherwise to the administration of justice, must uphold the continued independence of the judiciary.
Does that include the Secretary of State for Defence if the claim is brought in relation to court-martial?
It would, my Lord, yes. My Lord, subsection 4, the following particular duties are imposed for the purpose of upholding that independence. And subsection 5, the Lord Chancellor and other ministers of the Crown must not seek to influence particular judicial decisions through special access to the judiciary. And subsection 6, the Lord Chancellor must have regard to the need to defend that independence. And my Lord, for the completeness, the definition of the judiciary, unsurprisingly, includes the judiciary of the Supreme Court and any other court established under the law of any part of the United Kingdom. If your Lordships could then turn over to section 17.
And court is, again, court presumably is defined somewhere to include tribunal.
Lord, I'll have to check the other sections of the Act.
It would be surprising
but
if
it
it
would be
wasn't.
very odd if it didn't.
No, quite. Okay.
My Lord, section 17 over the page is the Lord Chancellor's oath of office. And this provides that the oath should be tendered to and taken by the Lord Chancellor as soon as may be after his acceptance of office. And the oath is, I do swear that in the office of Lord High Chancellor of Great Britain, I will respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provision of resources for the efficient and effective support of the courts for which I am responsible. So that is the oath of office that is taken by every Lord Chancellor. And my Lord, we say that codifies the long-established constitutional principles, and in particular the duties imposed on the holder of the office of Lord Chancellor to both guarantee judicial independence and uphold respect for the rule of law. Now, my Lord, what we say is that if the judge is correct, then in all of these cases, the Lord Chancellor is placed in what we term below a constitutional quandary. The Lord Chancellor must either uphold judicial independence and defend to the utmost every single one of these challenges that may be brought under section 91C of the Human Rights Act. That is so no matter how hopeless the defence, how advancing unarguable contentions offends the rule of law. Because were he to do otherwise, the Lord Chancellor would be accepting that a judicial act that has never been challenged in an appeal is unlawful and or wrong and or breaches convention rights. I can see your Lordship is looking quizzically at me, but my Lord, that is the inevitable consequence.
Yes, but why is that a breach of the duties you've just shown us? Because whether it is so will be determined by a court.
Well, my Lord, if the Lord Chancellor defends it to the utmost, then it will be decided by a court. But that may well involve, in certain cases, and I say nothing about the merits of this case, but it may involve the Lord Chancellor advancing utterly untenable arguments when faced with a judicial order that is obviously in breach of Article 5 of the Convention. But what the Lord Chancellor can't do, we say, is to reach a settlement with a claimant in such a situation, because the Lord Chancellor would then be agreeing with a claimant in a collateral challenge that a decision of the independent judiciary is wrong and paying out damages in respect of it. And that will be occurring in circumstances.
Would that be a
no
breach of
appellate-
these duties if it were a reasonable settlement?
But, my Lord, we would say yes.
Why?
Because that involves the Lord Chancellor and a third party reaching an agreement that a judicial order which has never been challenged, has never been appealed, is wrong. And we say that would interfere with the independence of the judiciary.
But you're challenging Mr. Justice Freedman's order. And the Lord Chancellor often challenges orders.
Well, my Lord, and when the Lord Chancellor is the party to the proceedings, because the Lord Chancellor is involved in the proceedings, then of course he can often appeal and challenge judicial orders. That is entirely appropriate. What is happening here, or what would be happening here, is a situation where a judicial order has been made in proceedings to which the Lord Chancellor was never a party. That order has never been appealed. It remains a judicial order. And in a different set of proceedings, the Lord Chancellor is agreeing with a claimant that that judicial order was wrong. That, we say, does offend against the principle of the protecting the independence of the judiciary.
If the Metropolitan Police settled a claim on the basis that the order authorising the detention was wrong, would that be a challenge by the Metropolitan Police to the rule of law?
No, my Lord, because the Metropolitan Police are not under a duty to uphold and promote the independence of the judiciary. They are simply reaching a pragmatic view about what their obligations may have been in a particular case. But the Lord Chancellor has not done anything in any of these cases. The Lord Chancellor is simply the defendant by virtue of Section 9(3) of the Human Rights Act. So the Metropolitan Police have done something in this case. It would involve the Metropolitan Police accepting that the thing that they did was unlawful and paying out damages in respect of that. Any public authority could do that. What's objectionable here is that the Lord Chancellor is never a party to those original proceedings. They are nothing to do with the Lord Chancellor. And the Lord Chancellor is then to come along if the judge is right. And either, as we say, he has to defend all of these claims to the utmost because he can't settle them, or if he settles them, that is what offends the principle of the independence, offends his duties to promote the independence of the judiciary.
Can I just ask you how you see an appeal would work in the particular circumstances of this case? We know the Mental Capacity Act provides that capacity is assumed unless the contrary is proved. These orders were set aside because the judge, she subsequently decided that he didn't have capacity, so had actually set aside the orders going forward.
Well, some of the orders, my Lord, set aside the injunction.
Yes.
They did not set aside, and indeed the order had never been set aside, of His Honour Judge Hellman, who remanded the claimant in custody for 21 days. That order has never been set aside.
But the order wasn't set aside, but the basis on which the set aside happened was because the claimant lacked capacity, although there's a dispute between Shuttleworth and Citron on that.
Yeah. Well, so, my Lord, the injunction, the interim injunction that was made on the 17th of February, was set aside on the 30th of June, on the basis that the claimant lacked litigation capacity.
So you have there a judicial finding, which I well understand the constitutional importance of keeping separation of powers, but you've got a judicial finding that he lacked capacity at the time.
Yes.
And then the claimant says, well, you just read that back and therefore we can claim damages, and no doubt you say, well, in fact, you didn't lack capacity or whatever other grounds of defence. Why does that infringe the court's independence?
Well, my Lord, because when one looks at Section 9 and when one looks at how it should be construed, the root or the precondition to a claim for damages is, we say, that the appellate court will determine whether that is a breach of Article 5 of the Convention. And that is what the claimant could do in this case. They could appeal the order, that was in force between the 17th of February and the 30th of June on the basis that it was a breach of Article 5 of the Convention.
But the court could also, and I think my Lord the Vice President had put to you, the court could also have simply said, we'll allow the appeal because he lacked capacity and therefore shouldn't have been granted this order, and say nothing about Article 5. Indeed, I mean, judges are quite often told not to go on diversions in their judgments and just decide the issue before them.
Yes, but my Lord, at this point, because the claimant wants to bring a claim for damages, he has to establish that there's been a breach of Article 5.
Which he can do then in the subsequent action.
Well, my Lord, that could be done, but we say the route that should be taken, the route that Maza says should be taken, is to appeal it on that basis first.
Well, we'll get to Maza in a minute, and at some point we'll also decide how to pronounce it. But as a matter of principle, separate from what said in that case, I still don't quite understand why you're saying it has to be done by way of appeal.
Well, my Lord, because the issue that's being raised is, does this judicial order, breach the claimant's convention rights? We say you appeal that first. We say the whole structure of Section 9, when one looks at the parliamentary back history, one looks at the purpose that it's trying to serve, is that that is an issue that must be raised on appeal first, determined by the appellate courts, and then, if one needs to bring a claim for damages, then one brings that as a Part 7 claim under 91C. But once one has the appellate determination as to whether it breaches Article 5 or not, the Lord Chancellor could settle a claim.
Which is the order that should be appealed? Is it Judge Hellman's order?
Well, my Lord, there are a number of orders that are being challenged by the claimant and being said to breach his Article 5 and or Article 6 rights. And it goes through every judicial order that has been made, that was made in the course of these proceedings. But it includes there are two aspects to this. One is the injunction, which contained the power of arrest, which was continued or not set aside on a number of occasions up to the 30th of June. And then the second is the remand that was made by His Honour, the order for remanding the claimant in custody, that was made by His Honour Judge Hellman on the 19th of May 2020, where he was remanded in custody for 21 days. So both of those two categories, if I can put it that way, of orders are challenged. Now, before the judge, or after the hearing before the judge, the parties agreed a note, which is in the supplementary bundle, which sets out the mechanism by which appeals against all of those orders could be consolidated, brought together and determined in one hearing before one court. And
yes, I hadn't perhaps sufficiently focused on this. Can I just think aloud for a moment and tell me if I've got this right? For each cause of action, or rather each detention gives rise to a separate cause of action. Each detention is said to have been a breach of Article 5 because the power under which, or the order under which he was detained was was unlawful in the sense that that the order was reached in breach of the of convention rights. Now, perhaps we haven't sufficiently bottomed out. We may have to hear from Mr. Westgate about this. The respect in which the relevant order breached human rights. But broadly speaking, it will be that he was someone who lacked capacity at the time the order authorizing the detention was made.
Well,
now, which order was that? The detention starts at the moment of arrest. So the power of arrest was granted by the original order of the 11th of February. So they have to challenge that order. on each of the subsequent occasions when he was arrested and brought to court, with the exception of Judge Hellman, no other judge makes an order remanding him in custody. Is that right?
That's right, my lord, yes.
So effectively, the two orders which have to be said to be in breach of human rights are one, the original 11th of February, and two, Judge Hellman's order, of which the date I've forgotten, but you'll tell me.
19th of May.
Sorry, 19th of May. Is whatever's pleaded, subject to what Mr. Westgate may say, does that seem to be the correct analysis?
Well, my lord, if we look at the particulars of claim, they're in the core bundle at tab 7, at the relevant section at page 87.
Give me a moment.
So the claim...
Hang on 1 second. Yes, thank you. I've got the original claim.
Yes, core bundle, page 87 is where the particulars of claim, or the particulars of breach.
Yes.
start. So the claim as against the Metropolitan Police is pleaded as a claim of false imprisonment and or breach of Article 5 on the basis that there was no lawful authority for the police detaining the claimant because the court order was various terms void, no effect.
We say the court order. Which court order did they plead?
I assume that is the 17th of...
Well, hang on. Just looking at the structure of this, subpara A says actually it's for you to plead, but helpfully they plead a positive case of unlawfulness, and
it's put
B makes effectively the domestic law point that it's unlawful or at any rate wrong, contrary to CPR 2134.
Well, this is the claim, my lord, against the police. Where
I understand that, but you took us to that first.
Yes.
I'm just trying to pin down which orders, which orders are going to be in practice have to be shown to be made in breach of Article 5 or Article 6.
My lord, the way it's pleaded is that there's a long chronology of each and every order made in this case, and then the pleading says in respect of all of those orders. So it starts on the 17th of February, but it said that each order made subsequently was in breach because it continued the unlawful state of affairs that started on the 17th of February. That's the way it's pleaded.
But we're really only interested in the ones that authorise detention.
Yes. My lord, yes.
Well, in fact, it's even narrower than that. It's the ones that resulted in
Yes.
Detention. Yes. Yes, because if the claim is never detained, then there's no Article 5 or Article 6 breach. But my lord,
So you would accept my thinking on my feet analysis, I'm afraid, that we're really concerned with the only orders that the claimant has to show were unlawful were the original order and that of Judge Hellman.
yes. As I say, my lord, a lot more are pleaded, and it's a matter for Mr. Westgate how he pleads the case. But essentially, that's the premise.
Yeah, well, we'll have to ask him about that.
But if one then scrolls down to paragraph 43, the way the claim is put against the Lord Chancellor is that the orders are effective and did do something, because if the judicial orders don't do anything, then there is no claim under Section 9, because there is no judicial order that can have breached the claimant's Article 5 rights. So it's put in the alternative, if contrary to the claimant's primary, paragraph 43, if contrary to the claimant's primary position against the police, the injunction was not in effect, in other words, the orders are existing, the judicial acts described in paragraph 9 to 28 above, individually and or cumulatively, amounted to a breach of the claimant's right to liberty under Article 5. So one then goes back to paragraphs 9 to 28, which sets out essentially the chronology and lists every order that was made in this case.
But then, sorry, this is a point which I think everyone else has assumed I'm only really just focused on. At what appear to be the two material dates, 11th of February and 18th of May, 19th of May, we have to, insofar as the essence of the breach of convention rights is the lack of capacity, we have to show there was a lack of capacity at those dates, not simply at the date of District Judge Swan's discharge of the injunction.
Yes, a lack of litigation capacity.
Sorry?
A lack of litigation capacity.
Yes.
What one has to
Well,
ask for capacity.
litigation capacity, I was thought and injunction capacity, but
they are two different.
we needn't argue about that for the moment.
And then
So is there an issue as to whether there has in fact been a finding of capacity at those two dates? Because on the basis that the subsequent findings, I am right, aren't I, that District Judge Swan only discharged the injunction for the future.
Yes.
It was not appropriate for her. It is her, I think. For
I
him
don't
or
actually
him.
know, my lord.
No, not appropriate for him.
I'm
or
told from behind me it's him.
All right, so it's not appropriate for him to make any decision about the past.
My lord, that's what we say. There are very specific findings made at various points in the chronology as to whether the claimant had or did not have litigation capacity, and in respect of different sets of proceedings. So His Honour Judge Hellman on the 4th of, I'm just checking the date, on the 9th of June, found that the claimant lacked litigation capacity in respect of the committal proceedings that were being brought against him. Now, one may well infer that if he lacked litigation capacity for the committal proceedings, he also lacked litigation capacity for the injunction proceedings. But in terms of what was actually found in each of these cases, it is, in respect of each of these orders on different dates, it is slightly different things. And those do not, because litigation capacity, because any question of capacity is time specific, the fact that it's been found on date X doesn't necessarily mean it's been found 4 months earlier on date Y.
We're concerned, are we, with the order that was made by District Judge Manners? Is that right? That was the operative order at the time when the claimant was arrested.
Yes, so that was made on the 17th, not when he was arrested, my lord, that was the 17th of, that was the 17th of February 2010.
That was expressed to remain in force until February 22 with a return date.
With the return.
Then there were various adjournments which don't seem to have altered the order itself.
Yes.
On the 18th of May, claimant's arrested, and he's brought before the court on the 19th, and that's when he's committed.
Yes, so there were two hearings, my lord. I don't know if your lordship has the chronology. It's in the core bundle, page 50. But yes, core bundle, page 50. I've taken that out. So on the 19th of May, there were two hearings.
Yeah.
There was the adjourned return hearing, and then the committal hearing before His Honour Judge Hellman.
Yeah.
And my lord, it's not my pleading, but the way that Mr. Wesley puts the case is that each of those orders made, or each of the judicial orders on each of the return dates are also a breach of Article 5 because they did not correct what had happened on the 17th of February.
But they didn't result in detention.
My lord, all I'm trying to say to the court is how the case is pleaded.
Yes. I mean, what resulted in the detention was the order made by District Judge Manners, which remained in force despite various adjournments and commissions to have expert evidence.
Yes.
Until the time of the claimant's arrest on the 18th of May. That's the first detention.
Yes.
He's brought before the court on the 19th, and it's at that point that he's committed.
But, sorry, I'll let you answer that point first.
At that point, he's remanded in custody for the purpose of obtaining a medical examination under powers in the Antisocial Behaviour Act. So it's the two. One is the injunctions. Your Lordship said one is the interim injunction. One is the remand in custody.
Yep.
Both of those orders are said.
But there's a refinement of that. There's two. Obviously, the remand in custody is by far the most significant because he's kept for however many weeks it
21
is.
days, my lord, yes.
But each of the previous arrests leads to an overnight detention.
Yes.
And those are part of the claim against
Yes.
you. Now, those overnight arrests, I put to you, my lord has just put to you, really go back to District Judge Manner's order. In fact, it's not quite right, is it? Because the first one was pursuant to District Judge Manner's, I think.
Yes.
Oh, wait a moment.
My lord, so the first...
No, hang on. Well, forget that. But my point is that was time limited. I haven't actually looked at the terms of the orders. It was until the return date.
No, until February 22, according to the pleading,
Yes.
with an interim return date. So
What I'm getting at, and what we just need to pin down just to be accurate about this, is whether, if it was indeed time limited, we can check, it would have to have been renewed. The actual operative order will be made at the renewal date, which would be the return date, effectively. Yes. So, in fact, the question of capacity arises each time the order is remade.
Yes, and that's the way...
If it was made on another way, you could have framed it, but it doesn't look as if it was framed this way, is he makes it indefinitely, but with a return date, which effectively means that unless it's altered the return date, the effective order remains the original order. But if he actually makes it time limited and it has to be renewed at each return date or after each adjournment, then you've got to look at the position at each such order.
Yes, and my lord, it's...
We've got the terms of the orders
We have
here.
the terms of the order. Terms of the order itself is in supplementary bundle, page 58.
You say that's the 11th of February.
That's the 17th of February.
17th of February.
It is fair to say it is not entirely clear on the face of the order which one of those two alternatives were being addressed. But the order is at supplementary bundle.
Sorry, it's the first time I've looked at it. I'm afraid I've just looked at narrative accounts of it, so just give me a moment.
Well, page 59, it says that under 9, it will remain in force until the 17th of February, unless before then it's reverted.
Yes.
Yes.
My lord,
So it is time limited.
But then it says...
So sorry, just give me one moment.
Yes,
The date of the order is what?
17th of February 2020, my lord.
Well, how about that's a nonsense then, isn't it? It says this order will remain in force until the day it's until today.
Yes.
That's obviously a
No,
slip.
Well, no, 22, my lord.
22.
Oh, 22.
So it's 2 years.
I'm sorry, 2
So
years.
this order will remain in force until the 17th of February 2022.
I'm so sorry.
Unless before then it is revoked by a further order.
So the arrest and the remand took place during the currency of this order.
Yes.
Yes.
Yes. So the refinement I suggested is not right.
Well, my lord, but then the order goes on under notice of further hearing. Because your lordship see that slightly further down the
Yes,
page.
but that doesn't affect that's true, but that doesn't the further hearing is not built into the structure of the currency of the order.
No, but it does say the court will reconsider the application and whether the order should continue.
Yes, but if it decides that it should continue, it doesn't, on the structure of this, have to make a fresh
They don't
order.
make a new injunction
No.
order on each.
Thank you. Well, I'm sorry, I've wasted 5 minutes, but it's worth.
Not at all. my
Let's
lord.
just check
It's
whether
not
that was
entirely
followed.
clear.
Let's look at what the order made on the return date. Where do we find that?
That is the order made on the 3rd of March, my lord, which is at supplementary bundle, page 83.
Made on the 3rd of March, but issued on the 12th, yeah.
And it adjourns the return date and makes provision for a report from a clinical clinical psychologist or educational psychologist to be served.
Yes, but the key point is that there is nothing remaking the order of the 17th of February, although it is varied in one respect. But
it's varied in respect of the other defendant,
yeah.
the MTA's brother.
Yeah.
The order is varied. This order, the injunction order we've looked at, is varied subsequently. The boundary line of the order was varied on the 29th of May, which is at supplementary bundle page 147.
Right, but even there, there's not a fresh order being made. It's a variation of the order of the 17th of February. So,
well, my lord, at 147, you see there is a fresh document headed injunction order.
the label itself isn't important.
What it does is it varies the map. It substitutes.
Well, let's just. Yeah, all right. Query. What's the date of this order?
That is the 29th of May 2020.
Are we missing part of it? Because paragraph 8 seems to finish with the semicolon and you turn the page and hope and get nothing.
My lord, I had not noticed that. It is quite possible the Lord Chancellor did have, or those instructing me did have considerable difficulty in locating the orders.
I can imagine all about that. That's just why I wondered.
My lord, I agree with you. It does look as though it cuts off.
I'd be grateful, nevertheless, that we could be checked whether this is because you've never been given the complete order or whether somebody has been an error in the bundling. I think we'd obviously like to have a complete order if it exists. It might even be, if it's possible to get in touch with the county court and get the complete order now, I think that's worth doing.
Yes. My lord, my instructor's solicitor sits behind me. She'll take steps to
thank you.
To source those.
Right, well, that's been helpful. Sorry, my questions largely took you a little bit away from where you were. I think it actually started, according to my note, my Lord Justice Dingemans asking you how your analysis would apply to the order made in this case.
Yes. My lord, I think where we've got to is I'm essentially going to what was heading 3 on my list.
Yes.
What was decided in Maza.
Yeah.
Your lordship did say to ask how it was actually
Yes.
pronounced. I was in court, my lord, at the first instance hearing when Mr. Maza was there and he gave evidence to the judge. He pronounces his name as Maza, which is why I pronounce it as Maza.
I should have trusted you, Mr. I've been calling it Mazhar, just as ironic I am. Right, thank you.
My lord, I want to start by showing your lordships what was decided at first instance, because that is an important point to understand what was decided on appeal. And my lord, the first instance judgment in Maza is at tab 14 of the authorities manual, page 218. And as your lordships will know, this was a judgment of Lord Justice Ryder, who was appointed by the President to sit as a judge of first instance to determine this case. And we see the background in the facts in the head note, which I could invite, if I could just invite your lordships to read the first section below above on the claim. I'm sure your lordships have read Maza, but the issue is that Mr. Maza had capacity to make decisions for himself, but he was very physically disabled. He needed round-the-clock care. The NHS Trust formed the view he'd be at risk of severe injury or death if he were not removed to a specialist respiratory centre. The claimant and his family refused to agree to this. They thought he didn't need it. On an urgent, without notice, out-of-hours application by the NHS Trust, an order was made under the inherent jurisdiction of the High Court.
Speaking, I'm sure we are very familiar with the facts, and this is something you want to...
But in terms of the 3 findings made at first instance, those are summarised helpfully in the head note, and then I'll take your lordships to what was actually found. So under the holding 1, nothing in section 7, 8 and 9 of the HRA created a power in the Court or Tribunal to grant declaratory relief against the Crown in respect of the Judicial Act. So that's the first finding. The second finding, under paragraph 2, that to the limited extent that the sections of the Act created a freestanding right to damages against the Crown in limited circumstances for a judicial act in breach of Article 5.5 of the Convention, the general principle that the Crown was not liable for judicial acts was dislodged, that where the judicial act complained of was that of a High Court judge, a claim for damages under Section 9.3 of the Act could not be brought in a court of coordinate jurisdiction, and so had to be made by way of an appeal to the Court of Appeal. So that's the finding that Lord Justice Ryder made. And then 3, applying those principles, the claimant's claim for declaratory relief against the Lord Chancellor was not justiciable. It was open to him to seek damages against the Lord Chancellor under Section 9.3, but, said Lord Justice Ryder, such a claim fell to be raised in the context of an appeal against the order of the judge to the Court of Appeal. So in other words, the damages claim had to form part of the appeal under Section 9.1a of the Human Rights Act. And I'll show you, Lordships, that in a moment.
Yes, I mean, the third holding, as analysed by the reporter, is really just the consequence of the first 2.
Yes.
Yep.
So, my Lord, in terms of the judgment itself, that starts at page 225 of the exam report. And we have at paragraph 2 the actual order that was made by Mr. Justice Mostyn. So paragraphs 1, 2, 3 and 4 are all declaring that it is lawful, so it's giving lawful authority for other people, third parties, to detain, to deprive the claimant of his liberty. And we see from paragraph 3 of the judgment that clause 4 of the order was discharged by Mr. Justice Holman on the 23rd of May, after the order had been put into effect. So there is a part of the order that was permitted to be appealed, had already been discharged by the time of that appeal. But the remainder of the order remained in force. It had neither been appealed nor otherwise varied or set aside.
Hang on 1 second. Yes, sorry. When Lord Justice Ryder says that the balance of the order remains in force, the effect of the discharge of clause 4 was presumably that Mr. Maza was returned home.
No, my lord, it was accepted that he had capacity to make his own decisions where he resided, and he chose to reside in the hospital.
Oh, I see.
There was no need for an order authorising his deprivation of liberty. So he agreed to stay there.
And to say that clauses 1 to 3 remain in force, I see that's formally the case, but they are all, in a sense, they had at that time no current relevance because they were all related to acts which had already occurred.
Yes, but they'd never been set aside, my lord.
Yeah.
They hadn't been discharged. And then, my lord, paragraphs 4 and 5 set out the basis of the claim, what was actually claimed in these Part 7 proceedings. So, paragraph 4, you see Mr. Maza's claim as originally pleaded is for a declaration that the NHS Trust and the Lord Chancellor breached his rights under Article 5, 6 and 8 of the Convention. And, over the page, and for damages against both the NHS Trust and against the Lord Chancellor for breaches of Article 5 of the Convention. So there was a Section 9.3 claim for damages against the Lord Chancellor. What then happened is that Mr. Maza compromised his claim against the Trust by accepting a Part 36 offer of damages, this is paragraph 5, in the sum of £10,000. So that part of the claim against the NHS Trust was stayed under Part 36. The Lord Chancellor was notified of that in writing, and Mr. Maza then confirmed that in light of the settlement of his claim against the NHS Trust, he no longer sought damages against the Lord Chancellor, and the remedy pursued was that for a declaration. However, the claim for damages remained, and as I'll show your lordships in a moment, that was the basis upon which an appeal was then fundamentally made. That damages claim, that nominal claim for damages, is how we got around some of the procedural issues. So, my lord, one sees then at paragraph 18 on page 2.
Sorry, I'm being slow. Nominal claim for damages remain.
Against the Lord Chancellor. So one couldn't get double recovery. Having accepted a settlement from the NHS Trust for the detention, the deprivation of liberty, one couldn't get double recovery and get damages from the Lord Chancellor rising out of the same deprivation of liberty. But nevertheless, he retained a nominal claim, what he formulated to be a nominal claim for damages.
Wouldn't a claim for nominal damages be susceptible to being struck out under the Jameel principle? Game's not worth the candle.
Well, my lord, that wasn't the approach that the Court of Appeal took,
No.
for perhaps obvious reasons that they wanted to allow that order to be.
And in what sense was it nominal? I mean, the fact that you get damages against, if you have joint tortfeasors, well, there is some law about this, isn't there? But if you have joint tortfeasors, you can settle against one for less than you say the full amount of your claim is, and proceed against the other for the balance, don't you?
Yes, I mean, it's simply the way the claimant formulated his case. He wouldn't seek the full loss against the Lord Chancellor, full damages against the Lord Chancellor, but he retained what he used as the phrase nominal damages against the Lord Chancellor. In the event, my lord, no damages were paid out because the Court of Appeal found there was no breach of Article 5, and that's somewhere down the line in chronology terms. My lord, if I could ask your lordship to turn to page 230. We see what happened. So that Mr. Justice Mostyn's order had made provision for listing a return date. We see paragraph 18. After the order was made, the proceedings continued, but not in the way that Mr. Justice Mostyn had envisaged. Paragraph 5 provided for an urgent return date, but neither the NHS Trust nor Mr. Maza made an application for a return date until the 9th of May 2016. And it was Mr. Maza's solicitor who made the application, not the Trust. This was listed to be heard before Mr. Justice Holman, and then Mr. Maza's counsel indicated in his position statement an intention to seek damages against the Trust. And at the hearing before Mr. Justice Holman, Mr. Maza, this is the point I was making to your lordship, Mr. Maza consented to the continuation of his treatment at the hospital, with the consequence the judge discharged the paragraph that authorised his deprivation of liberty there. So, my lord, in terms of how Mr. Justice Ryder approach these issues. The first issue starts at paragraph 35, page 234. And we see at paragraph, just slightly above that, paragraph 34, the first question is accordingly one of statutory construction. Does section 7 of the Act, read in the context of sections 8 and 9, and the provision of CPR, create a power to grant a declaration in respect of a judicial act that breaches the convention? The answer we see from paragraph 39 and 40 to that question was no. And at the bottom of page 235, where we have paragraph 40, just towards the bottom of the page, does your lordship see the sentence starting accordingly? Accordingly, the power that is created by the statutory scheme is the power to award damages for breach of Article 5.5 of the Convention. The reasons which follow have also come to the conclusion a freestanding power to grant a declaration outside of the appellate or judicial review context runs the risk of a minister being able to agree with the claimant in collateral proceedings that a judge is wrong without having to have recourse to an appeal or a review of the substantive proceedings by an appropriate court or tribunal. So that's an essential part of Lord Justice Ryder's reasoning. We then see the subheading above paragraph 42, the second issue of judicial immunity. Given the Court of Appeal's approach to this, I don't need to get into the detail on it, but essentially Lord Justice Ryder found that judicial immunity was preserved by the Human Rights Act, but there is nevertheless an enforceable right to compensation for the victim of the breach of Article 5.5, and that's at paragraph 54 to 55. But at paragraph 57, page 239, the two purposes one sees in paragraph 57, Lord Irvine described the amendments that are now the subjects of section 9 as having two purposes: giving a right to compensation for breaches of Article 5 and preserving judicial immunity generally. And if I could invite your lordships just to read that extract.
We will, Benioff. I seem to remember that in the Court of Appeal, they said that it was not appropriate to have regard to the debates.
They did, my lord. I'm simply showing your lordship what formed part of the reasoning of Lord Justice Ryder at this point, which does set out what the purpose said by the government was.
Okay, well, we'll read them on that basis. Yes.
Well, Lord, the third issue then is, starts at paragraph 65, page 242. That was the issue of vicarious liability, finding the obvious point: the Lord Chancellor can't be made vicariously liable for the actions of the independent judiciary. And it is the fourth issue, which starts at the bottom of 242, which is important for present purposes, because this is the issue about about abuse of process. And the argument that was advanced, that we advanced on behalf of the Lord Chancellor, is that it is an abuse of process to challenge an order of one judge sitting in the High Court before another judge sitting in the same or a coordinate jurisdiction. And the submission there made was that the purpose of section 91C is to provide a subsidiary route to an award of damages by the civil courts, where that could not be determined on an appeal or a claim for judicial review. The argument was, you make the claim for damages in the appeal, and section 91C only has a role when that isn't done. And paragraph 68, that approach is made express in the Scottish rules, and it was said it's arguably not a necessary implication of the English rules, and I shall therefore deal with it. So paragraph 69, Mr. Brzezinski set out another extract from Mazhar, and Lord Justice Ryder concludes that the subsidiarity relied upon is plain from the language of the legislation and from the rationale that can be derived from the authorities to which I have referred. But if I'm wrong, then it's appropriate to consider the Hansard record, which confirms my view. So the same debate on the report, Lord Irvine says, and my lord, if I can invite your lordships to read that extract as well.
Not quite the point you're on, but if I just raise it now, because it's puzzled me slightly. Lord Irvine seems to take it for granted, and most of the discussion seems to take it for granted. There's nothing surprising about the appeal court making an award of damages for the act of the lower court.
Yes.
I mean, normally that's something which never happens.
Yes.
But it's just said to be there in 9.1, a combination of 9.1 and 7, 9.1a and 7.
Yes.
There we are.
Well, my lord, it's because it was essential, in order to give effect to Article 5.5 of the Convention, to be essential that there is a claim for damages arising out of a judicial act, which had never been enforced in the United Kingdom before the Human Rights Act. So what Lord Irvine is discussing here is, well, how do we do that? Section 9 has to do that.
Yes, no. Well, I see that is what he is saying.
So just take this case. An injunction is granted by the district judge, by DJ Manners. And claimant says, well, that shouldn't have been granted because I didn't have mental capacity at the time, litigation capacity at the time. So he appeals against it. The respondent to the appeal is the landlord. Which court is going to make an award of, which appeal court is going to make an award of damages, and against whom?
Well, my lord, as we'll see in the Court of Appeal in Maza, that was the reaction that the Court of Appeal had, and said you can't be expected to bring a claim for damages in as part of the appeal itself.
And the landlord anyway has got no interest in the appeal, and no doubt would oppose an application of penal time, not least because there's a costs risk.
Yes. But my lord, I completely accept that.
So how does the Lord Chancellor give permission to or consent to an application for permission to appeal if the landlord opposes?
Well,
What businesses did it with the Lord Chancellor?
That's what happened in Maza. The NHS Trust didn't oppose it, or they didn't. They asked to be discharged as a party, which is what I'll show your lordship that is what happened in Maza.
But those are both public bodies. Here, the landlord, as we know from the submissions that were made on the transcript, was strongly of the view that the claimant, that the respondent had capacity. They relied on Singleton as being accurate, and they're unlikely to want to get involved in that when the injunction's been discharged. I mean, why should they be dragged back to court?
And my lord, that's the view the NHS Trust took in Maza, and the Court of Appeal discharged them from being a party to the appeal.
Well, we'll get to that in due course.
I'll show you, lordship, that in a moment. But just to conclude what Lord Justice Ryder found to be the abuse, we see that at paragraph 71. It is no answer to the statutory construction point as regard 91C to say there would never have been an appeal to the Court of Appeal on the facts of this case, because good practice dictated first that a return date inter partes should be considered, and second that the deprivation of liberty clause was discharged by consent. So Lord Justice Ryder says that's no answer. First, not all of the clauses that cause the convention breaches were discharged, and second, in any event, in respect of all of the clauses, it is not the function of the High Court judge sitting on a return date to adjudicate on the lawfulness of what another High Court judge has ordered on a without notice hearing. So it's about the two High Court judge issues.
Well, is that? Suppose that's right. Well, again, we're going to have to look at what the Court of Appeal said,
yes.
But suppose on a return date, it becomes clear that the original order was wrong because it was, the present case is quite a good example. Suppose somebody to facts being as alleged that there was no capacity from the start. But another example might be it becomes apparent there was serious non-disclosure by the claimant seeking the order. I can think of other examples. The judge on the second occasion will certainly discharge the order, but he or she will inevitably, if those are the reasons, make a finding that the order should never have been granted. And was wrong from the start. Now, you can argue out whether it was nevertheless unlawful, because it's trite law that it remains effective until discharged. But for the purpose of for the kinds of issues we're concerned with here, I'm not sure it's right to say that the second High Court judge hasn't adjudicated the lawfulness of what was done on the previous.
Yes.
Done first time round.
My lord, that's a point that the Court of Appeal disagreed with Lord Justice Ryder.
I'm sorry, I'd forgotten that this particular point was it? I see.
My lord, I'm trying to set it up to show what it was that the Court of Appeal was determining on appeal, and I'm doing that by showing your lordship what Mr. Lord Justice Ryder found, and then I'll show your lordship the answer that the Court of Appeal gave to it. But paragraphs 72 and 73 are important. Where Lord Justice Ryder found that it's plain that the inability to obtain elsewhere a remedy prescribed by Parliament in respect of the judicial act of a judge of the High Court must open the door to the permission being granted to bring an appeal about that act to the Court of Appeal, where the jurisdiction undoubtedly exists to provide the remedy. To use the language of CPR Part 52, there is some other compelling reason for the appeal to be heard if the remedy is only available in that court. And then the nature of the abuse is formulated in paragraph 73, that to use section 91C in that context, without having pursued an appeal, is an abuse of process. And in the alternative, it was submitted that it is wrong to use 91C where the appellate route remains available, i.e. there is a priority of process in the language of the legislation. He also submits that it's an abuse to pursue what is in effect a substitute for a personal claim against a judge, which could have been brought by statutory appeal. And Lord Justice Ryder agreed with each of those formulations of the abuse.
May I just ask one question on that proposed procedure? There are difficulties on appeals where we're sometimes asked to allow appeals by consent. You're first of all suggesting a new structure where we require someone to appeal against a party who's got no interest, where the Lord Chancellor's principal interest is now not to undermine judicial independence. And so what, the Lord Chancellor is going to come and argue it, or will allow the appeal by consent, or will just settle it?
Well, my Lord, as we say the approach in Maza was the right one, the Lord Chancellor did not play a part in that appeal, and the court appointed, because of these constitutional reasons, and the court appointed an advocate to the court.
So, to avoid an abuse at first instance, the court's now going to have to start routinely in Article 5 cases appointing an advocate to the court.
Well, my Lord, if the court thinks that's necessary.
To adduce the evidence that the landlord might have wanted to adduce, namely that Mr. Shuttleworth was right.
Well, that's what we see in Maza, that's the approach that the Court of Appeal took.
Thank you.
And my Lord, just to be clear, I'm not suggesting in this case that the right route is that any claim for damages has to be attached to an appeal under section 91A. The Court of Appeal in Maza rejected that submission. So what I am saying is that one must appeal first, and then if there's anything left, there can be a claim for damage, a Part 7 claim for damages against the Lord Chancellor.
Now, Lord Justice Ryder says that that's what the rules in Scotland require.
Yes.
Why doesn't the Lord Chancellor exercise his rule-making power and require it in England?
Well, my Lord, because the Lord Chancellor says it's not needed, because on proper interpretation of the provisions, that's where we get to anyway. Now, if your Lordship finds against me on this appeal, that may well be something that the Lord Chancellor needs to consider. But after Maza, the view is taken that that is what the Court of Appeal in Maza mandated, that is the proper interpretation of the provisions. My Lord, just to finish the first instance judgment, if I may, paragraph 78 on page 245. Just under the letter F, a claim for damages against the Crown is available to Mr. Maza for the limited purpose of compensating him for Article 5.5 breach, but the forum for such a claim, where the judicial act is that of a judge of the High Court, cannot be a court of coordinate jurisdiction. On the facts of this case, the only court that can consider a damages claim is the Court of Appeal. So that's the finding against which the appeal was brought. And paragraph 79, if Mr. Maza wants to pursue his challenge to the order of Mr. Justice Marsden, he must do so on appeal.
So, just applying that to the present case, the two orders in question are one made by a district judge and one made by a circuit judge. So why can't a High Court judge decide whether or not they're lawful?
My Lord, they could. On the facts of this case, of course they could.
So why is it an abuse of process?
Well, my Lord, I'll show.
What Lord Justice Ryder is concerned about is what one court saying that the decision of a court of coordinate jurisdiction was wrong in some way. But that doesn't apply to this case.
My Lord, completely. And took your Lordship to these paragraphs to show that when the Court of Appeal in Maza is making the observations it did, it is in respect of that finding, and they have the same, I think it's fair to say, quizzical expression that your Lordship has as to why would that, how could that work. So that's why I've taken your Lordship to it. When we read the Court of Appeals judgment, we're reading it on the basis that it is an appeal against that conclusion. So with that introduction, could I ask your Lordship to turn to the Court of Appeal decision, which is at tab 17.
Sorry, 17.
17, page
Thank you very
282,
much.
my Lord.
Thank you very much.
And we see the ratio of the decision in the headnote under the held letter F. And if I could just invite your Lordships to read that. So, my Lords, the judgment itself starts at page 287. And we see at paragraph 2 what is the main question which arises in this appeal. And that is, does the Act permit a person to bring a claim in the High Court for a declaration that an earlier order was an unlawful violation of his convention rights, or is the only remedy an appeal against that order? We then see at paragraph 26 on page 292 the grounds of appeal. I won't detain your Lordships on the first ground. The second ground was that the judge was wrong not to deal with the claimant's Article 5 claim on the basis that it remained a claim for damages. And then ground 3, the judge was wrong to hold that the claimant's claims could only be advanced on appeal to the Court of Appeal rather than in the High Court, and or he was wrong to hold that advancing the claimant's claims in the High Court amounted to an abusive process. My Lord, that's the appeal against the point that my Lord Justice Lewison and I were just discussing at paragraph 78 of the first instance judgment. And then the fourth ground, alternatively, the judge was wrong not to grant the claimant permission to appeal out of time against Mr. Justice Mostyn's order. My Lord, the Court of Appeal then looks at the correct construction or correct interpretation of section 9. That starts at page 294 of the judgment and paragraph 38. Do your Lordships have that? So the subheading, the correct interpretation of the 1998 Act, paragraph 38, always a promising start, we do not accept the submissions of either party before us in full. The central question which falls to be determined in this appeal is one which must be answered according to the correct interpretation of the 1998 Act. And we then see the discussion of the key statutory provisions which I've already shown your Lordship. And at paragraph 43, the court says, having looked at section 7 and section 8, the court says if matters had stopped there, the scheme of the Act would be clear. An Act, including a judicial act, made unlawful by section 6 would lead to the right to bring a claim under section 7(1)(a) and obtain appropriate remedies, not confined to awarding damages in section 8. But matters do not stop there. The Act must be read as a whole. And then paragraph 44, in relation to judicial acts, section 9 goes on to make more specific provision. Subsection 1 provides that proceedings under section 7(1)(a) in respect of a judicial act may be brought only, and then it sets out the 3 different ways. And then, as we shall see, the original version of the Human Rights Bill did not include paragraph C in subsection 1. If the original version of the bill had been enacted, it would have been clear that the only 2 ways in which proceedings could be brought under the Act in respect of a judicial act would have been by way of an appeal or by way of judicial review. And one then goes on to paragraph 46, where the court essentially sets out Benyon and says it's legitimate to look at the parliamentary history and to look at amendments that are made to the bill as it passes through Parliament. paragraph 47, the court agrees with that extract from Benyon. And as the authors themselves state, the legislative history, in particular the way in which a bill was amended during its passage through Parliament, may throw light on the meaning of the resulting act. And then at paragraph 49, over the page, the court addresses what was saw from the passage of the bill through Parliament. So when the bill was introduced in the House of Lords, Clause 9.3 provided that there should be no remedy in damages in respect of a judicial act at all. During the passage of the bill through Parliament, it became clear that that would place the UK in breach of its international obligations under Article 5.5 of the ECHR. It was for that reason that the government itself introduced an amendment which became the final version of Section 9.3 as enacted. As will be apparent, that provision makes it clear that in proceedings under the Act in respect of a judicial act done in good faith, damages may not be awarded otherwise than to compensated person to the extent required by Article 5.5. Then it sets out subsection 4, and no award may be made unless the appropriate person is joined. There is no, and at the end of the paragraph, there's no question of the relevant minister being vicariously liable for the judicial acts concerned. The court then set out the original version of Clause 9. And then at paragraph 51, when the bill was at committee stage in the House of Lords, it was pointed out by Lord Meston that Clause 9.3 is drafted will provide...
Well, this is really just, this is just putting more flesh on the bones of what's said in paragraph 49, isn't it?
Yes.
We need all this detail.
That's right. Well, my lord, the detail, the background is important because it takes us to the conclusion at paragraph 54. When the final version of Section 9 is read in light of its legislative history, it is clear that the way in which a judicial act is usually to be the subject of proceedings under the 1998 Act is by way of an appeal, or where it is otherwise available, by way of judicial review. The only circumstances in which a claim is permissible under Section 9(1)(c) is where that is necessary to enable a claim to be brought for damages for unlawful detention in breach of Article 5 in accordance with Section 9(3). My lord, I do emphasise both the usually there and the necessary.
Are you, just so that you can deal with the point, making the error of reading this as if it's a statute rather than just answering the appeal point before it?
Well, my lord, I don't say I am. I'm saying the Court of Appeal is giving clear guidance about how to interpret Section 9, and what it's doing here is setting out why one should interpret Section 9 in that way. And in our submission, that applies equally to this case as it did in Maza. My lord, at paragraph 56, that dealt with the first ground of appeal, i.e. that the Human Rights Act permitted a claim for a declaration. The Court of Appeal says no. The only kind of action that's contemplated by Section 9(1)(c) is a claim for damages for breach of Article 5. My lord, if I could then invite your lordships to move down to paragraph 60. The court there finds that the question whether a judge had jurisdiction to make an order is a question to be determined on appeal, not on a return date hearing. Leaving aside procedural issues arising specifically under Section 9, as a matter of general principle, whether a decision of a judge of the High Court can be set aside by the same judge or a different judge, or ought to be appealed to the Court of Appeal, will depend on all the circumstances. And my lord, this paragraph makes the point that your lordship was putting to me, that if there's a breach of the duty of full and frank disclosure, for example, the same or another judge of the same standing can set it aside. If, however, the attack on the order is, as in the present case, based entirely on a submission of an error of law, the appropriate course is to appeal the order to the Court of Appeal and ask for it to be set aside.
That, as I understand it, is inconsistent with the practice in the commercial court, where someone brings a cause of action and asks for a freezing order and says the claim of action is under a statutory provision. It's perfectly permissible to come back to the other judge and say they have no jurisdiction to make this order because the statute doesn't provide it. And the courts have said don't go to the Court of Appeal in those circumstances, have the contested argument at first instance.
Well, my lord, having never set foot in the commercial court, I'm not sure I can answer that question.
Well, I must say, it's my understanding of practice in the KB generally. I mean, it'd be bizarre if it were otherwise. Just the whole point is that the original order will normally be made without notice. And it's in those circumstances, without any bad faith or non-disclosure, that it's not unusual that the judge will make an error of law because he's only heard one side. The idea that because it's an error of law rather than non-disclosure, you have to go to the Court of Appeal is certainly not how I used to act when I went in 98.
But what I would say is, if I can put it as in terms of a clear-cut error of law, so when I say this order breaches Article 5 of the Convention, that's not a matter that's going to be argued on a return date. That is a question which says this judicial order breaches it is unlawful. It's not a return date question in my submission. It's not.
Well, I agree. So
Something...
what they appear to be saying, it just surprises me. I'm wondering whether it's ratio.
My lord, I probably wouldn't go that far, given that what's being discussed here is the approach to damages, when the issue in the case was whether there could be a declaration.
And in this case, one could one not say that what went wrong here was a question of fact? The judge assumed that the claimant had mental capacity when he didn't.
Well, my lord, with respect, I would say that's a matter of law, not a question of fact.
Well, whether he had mental capacity or not is a question of fact, isn't it?
It's a question of law, my lord. One has to apply the legal test set out in section 2
on the basis of the
mental
evidence.
capacity.
Absolutely.
My lord, one often finds determinations of capacity made in the Court of Protection are appealed as containing an error of law to the Court of Appeal. It's an error of law, in my submission. So, my lord, going back to the judgment, at paragraph 61, the court finds that ordinary course wasn't followed in the present case because all the parties accepted that the claim for infringement of Article 5 could be pursued at first instance by converting the claim into a Part 7 claim. At the end of paragraph 61, the position is that irrespective of any bar which may exist under Section 9 to a claim for a declaration against the Lord Chancellor, any such claim ought to be made by way of an appeal for an order setting aside Mr. Justice Mostyn's order on the ground of an error of law. But then we see at paragraph 62...
Hang on one second, just want to digest that. Okay.
So we see at paragraph 62, the court also rejects a submission on behalf of the Lord Chancellor that Section 9.1 is to be treated as imposing a statutory hierarchy, under which Section 9.1c can never apply. And that is the submission that it can never apply because you have to attach your damages claim, you have to make your damages claim in the appeal.
Hang on.
Because that was the submission.
Hang on.
I'm sorry, my lord.
Right. Yep.
So, my lord, that submission is what's being rejected there, i.e. you have to make the damages claim as part of your appeal under Section 9.1a. So that is what's being rejected in terms of the statutory hierarchy. And the court there says there's nothing in the 1998 Act that warrants such an interpretation. I accept that. So then we get to paragraph 63, which is what has caused quite so many of the problems. We accept that it may be an abusive process to make a claim against the Lord Chancellor under Section 9.3 by way of originating process in respect of an order which, as a matter of proper process, can be and ought to have been appealed. And my lord, we say that the may there is not there to indicate it will always be a matter of fact of degree, it will always be a matter of factual assessment. It's to because it wasn't necessary on the facts of this case to determine whether it would always be an abusive process to make a claim against the Lord Chancellor when the order could be appealed. The issue, as we said, was about the declaration in Maza. Could you get declaration under Section 9 of the Human Rights Act? But, my Lord, what we do say is that the principles set out by the Court of Appeal, taken to their logical conclusion, do show that it will always be an abusive process to make a claim against the Lord Chancellor, which, as a matter of proper process, can be allowed to have been appealed.
What's the proper relationship between paragraph 63 and paragraph 64? Where they say at the end of 64, can be and usually would be brought as an originating process.
Well, my Lord, what we say is that they're rejecting the submission we advise at first instance.
Yeah, no hierarchy.
That you have to do it, you have to bring your damages claim with the appeal. Yeah. What the court is saying is, no, you don't have to do that. You don't have to bring your damages claim as part of the appeal. You can bring a separate freestanding damages claim, but you have to have appealed first. Because it's going to be an abusive process if you don't appeal to challenge the original judicial order.
So you say paragraph 64 is expressed on the premise that there has been an appeal.
Yes. So it's, and my Lord, that's plain from the text. We do not think it right to say a claim for damages under 9(1)(c in respect of an order by the High Court must be brought on an appeal. So it's rejecting the submission that Mr. Brzezinski advanced at first instance, that when you've got judges of coordinate jurisdiction, it's going to be an abuse. You've got to do it on an appeal. You've got to bring your damages claim on an appeal. Saying that bit is wrong, says the Court of Appeal. So it's still saying you need to appeal first, but you can then bring a Section 9(1)(c claim. You don't have to bring your damages claim as part of the appeal.
If you have appealed and your appeal fails, there's no question of there being any unlawful act for which you can bring the claim. If, on the other hand, you appeal and your appeal succeeds, the order under appeal will be set aside. So there is no order. So what's the problem then about suing anywhere?
Well, my Lord, the order may be set aside, it may not. It depends on the remedy or the relief that the Court of Appeal grants. But you then have the determination that that order, that judicial order, was unlawful. That takes you back into Article 5(1) territory. If anyone has been deprived of their liberty, it's not pursuant to a lawful order of the court. One then has to go on to ask whether there's been a gross and obvious procedural irregularity in order to find a breach of Article 5. But that's the first stage of an Article 5 breach. If there's a lawful court order which has been upheld on appeal, one can't get an Article 5 claim for damages off the ground.
It's just as a matter of the structure of the judgment, paras 65 and 66, which are first and secondly, are clearly intended as reasons for para 64.
Yes, that's how I read it, my Lord. So it's the Court of Appeal expressing the same, dare I say, abject horror at the thought of having to deal with damages claims as part of an appeal, and saying you're not required to do that.
Hang on one second. Yeah.
Lord, the ultimate conclusion, as you say, is in paragraph 67. The central question of statutory interpretation, so this must be part of the ratio, is that 91C must be read with 93, doesn't permit a declaration, it only permits a claim for damages. And then, but 2, Lord Justice Ryder was wrong to hold that a claim for damages can only be brought by way of an appeal if it concerns a judicial act of the High Court. But we say that has to be read together with what is said in preceding paragraphs up to 63, that you should, as a matter of principle process, appeal the order first. So putting those two things together, we say what the Court of Appeal is concluding is one must appeal the judicial order, but then you can bring the Part 7 claim, if you're able to in light of the decisions on the appeal, for damages.
But what's wrong with setting aside the earlier order if you had jurisdiction to set it aside? Of course you can't have High Court judges setting aside an order, then next week turning back to the first judge who then sets aside the setting aside order. It would be a recipe for chaos. But if you've had a situation where it's come back for a further decision and the court has set aside the order, why is that not the same as a judicial declaration? It avoids your concerns about infringement of the separation of powers principles, and it is a perfectly principled answer.
Well, my lord, it does to some extent, but one still has the order that is in force, in this case from the 17th of February to the 30th of June, the injunction order, that had effects. Of course it had effects, because the claimant was detained pursuant to it. And the way in which my learned friend puts the claim is on the basis, the claim for damages against the Lord Chancellor is on the basis that that order had an effect. It had legal effects.
Well, that would be true even if it were, I mean, all orders once made, however wrongly, have effect until set aside. So your point proves too much, doesn't it?
Well, my lord, no. Because
that would be true if it were appealed.
But the appeal will look at whether the order was lawfully made from the point at which it was made to the point of the appeal. So one is appealing on my learned friend's case, one needs to look at whether it was the 17th of February and then each and every appeal.
But so is the essential point you're making is that certainly in this case, and probably always, I haven't quite thought this through, a set aside is never ab initio. It's only from the moment that the set aside is pronounced.
Well, my lord, we have the Supreme Court's judgment in the Rwanda case. I forget the name of it now, but I can get a copy where the Supreme Court is saying concepts of void ab initio, null, void, are inapposite to apply to orders at all. The basic principle is if the order exists, one is under a duty to comply with it.
I don't know which case you're referring to. It's not the recent Rwanda case.
It's the well, we'll just have a moment. It's Mazhar in the Supreme Court, SM Rwanda. I think, my lord, it was an appeal against one of your lordship's decisions.
Could be. It doesn't ring a bell at the moment. I mean, the general point that you've quoted is a point I'm familiar with. I'm just not familiar with the case. What's the case?
My lord, it's SM Rwanda and Secretary of State for the Home Department.
What's the citation?
2022 AC 461. I've got copies if it would help to hand it out.
If you have, I think we probably should have that. But can I, just while that's coming up, can I just be clear? My lord is asking, not me say the crucial question, a very important question. What's the distinction? You say it's been perfectly all right if this order had been quashed on appeal, but it hasn't been. Instead, it's been set aside. And I'm just trying to work out what the distinction is between a set aside and an appeal. And I was asking you whether the distinction is that an appeal makes it clear that the order was wrong, not necessarily void, but wrong ab initio, whereas a set-aside simply says it will cease to have effect.
Yes.
So that is your distinction.
Yes. My lord, that's my submission.
Hang on 1 second. It's not retrospective, in other words.
Yes.
Yes, well, I see that, and that then, and that, in a sense, all the niceties about exactly which order we were talking about doesn't matter, because all the orders under which he was detained, by definition, preceded the set-aside.
Yes.
The set-aside was just District Judge Swan saying not for the future. That's your case.
Yes.
Yeah.
No, and my lord, what we say about that, if I could, I'm going to come to it, but perhaps it makes sense to deal with it now. My learned friend says this can't be a collateral attack case, this can't be a typical abuse case because the orders have been set aside. And what we say to that is that my learned friend's claim as against the police is dependent on establishing that the order had no legal effect, there was no lawful authority for the detention. But the claim as against the Lord Chancellor proceeds on the basis that these orders were effective, that they had legal force at the time at which the claimant was detained. And we see that, my lord, in paragraph 43 of the particulars of claim, which is at core bundle page 89. And my lord, the reason for that's obvious. If the orders didn't exist, if the orders had no effect, then the judge hasn't done anything that can be the subject of a claim for damages under Article 5. If it doesn't exist at all, if it never existed, what is it? What is the judicial act that is said to breach the claimant's convention rights? So the claimant's claim against the Lord Chancellor proceeds on the basis that these orders are effective at the relevant time. And my lord, the second point is that the order of His Honour Judge Appellant has never been set aside. So the order that remanded the claimant in custody for 21 days has never been set aside. No court has set aside that order. No court has been asked to appeal, to opine on an appeal against that order. No, the claimant suggests that the automatic effect of CPR 21.34 is that the order is null and void from the point at which the court determined that MTA is a protected person.
We don't have that in the authorities bundle, do we?
We don't, my lord. We're trying to put it
You
down.
fairly assumed that we'd always have the white book in court.
I've got a copy of the chapter from the white book if you want to assist. I can hand that down.
Might be convenient. We do obviously have white books in our
Yes.
rooms, but they're no longer in court. They're not up-to-date ones. Thank you. I see you printed out the whole of the, well,
Just for completeness, my lord, one never knows what one might need. Page 612, my lord, on the bottom, the white book pagination on the bottom.
not as printed out. There are no page numbers.
It's 21.4.
My lord, I do apologize, then I have a different version. Can I have that?
Doesn't matter, but it's 21.3.
It's 21.
21.34.
Yeah.
It's at the bottom of what would be page, I'm not sure, 6, 7. Any step taken before a child or protected party has a litigation friend has no effect unless
My lord, it's a very strangely drafted provision, and we have all, I think, spent some time to see if there's some authority about what that provision actually means.
yes, and there's no commentary on it, is there?
There's no.
It has been used when you find someone's a protected party in the middle of a brain injury action, and you brought in as assault, and the junior has already compromised liability, for example, accepting a 25% deduction for seatbelts. So you then have to go to court and say, actually, the person was protected, and in fact, the compromise was a good one.
Yes, but my lord, that's right, and there is the Supreme Court judgment in. Terribly so. The name of it has completely.
Dunhill and Bergen.
Yes, thank you, my lord. That looks at precisely that point. If there's been a settlement, can that be unpicked at any point? But there's no authority at all on the proposition of what this does to court orders. I've looked for it. My junior's looked for it. I assume my learned friend and his junior have also looked for it. We've all come up a complete blank. And my lord, what we say is one has to interpret that in the context of the rule as a whole. And if one looks above at paragraph 21.32, when one refers to steps taken in the proceedings, or the term steps is reflected in Rule 2, so it's about the parties. A person may not, without the court's permission, and then take any step in proceedings, except issuing and serving a claim form or applying for the appointment of a litigation friend. So it's about things done by the parties rather than saying any court order is automatically somehow, one can use the terms null and void or whatever terminology that may mean. That's what it's talking about. Anything that's done in the proceedings, any step that's taken in the proceedings before the person's litigation friend has no effect unless the court orders otherwise.
But that would also include the court orders, because there was a court order, for example, agreeing the split at 75-25. It's just it was no effect until it was validated with the litigation friend.
Well, my lord, that's what applied in that context, but there you have the step. The step taken by the parties is agreeing the settlement, and it's that has no effect unless a court orders otherwise. And that's what the Supreme Court was looking at in the case that we mentioned. But the normal rule, and the rule in the Supreme Court in Mazhar, is that a court order must be obeyed unless and until it has been set aside.
Let's just look at that.
So that's, my lord, it's essentially an order from the first tier tribunal about release on bail, and then the Home Secretary decided to do something different on the basis that she said the first tier tribunal's order was ultra vires and therefore void, and she was free to ignore it. And the Supreme Court said, rejected that submission. And my lord, if one sees at paragraph 43 on page 480 of the internal submission, under the heading the duty to obey court orders. Paragraph 44, it is a well-established principle of our constitutional law that a court order must be obeyed unless and until it has been set aside or varied by the court. My lord, it sets out the rationale for that proposition. And then we have the paragraph 45, three important points to be taken from the passage. There is a legal duty to obey a court order which has not been set aside. It must not be disobeyed. This is a rule of law, not merely a matter of good practice. And then it sets out, the Supreme Court sets out why that is the case. And thirdly, the point thirdly in that paragraph, as the Lord Chancellor made clear in Chuck and Kremer, the rule applies to orders which are null as well as to orders which are merely irregular. Notwithstanding the paradox involved in this use of language, a court order which is null must be obeyed unless and until it is set aside. Well, there's lots more in the judgment about the rationale for that, but that's the key proposition. My lord, it's in that judgment of the Supreme Court where Lord Reid makes the point that terms about void, voidable, nullity are all confusing when referring to the status of court orders. They're concepts that apply to contracts rather than court orders as such.
I see it was indeed order of decision where I presided, though not where I did the judgment.
I didn't get that far, my lord. I saw your lordship was being appealed against, but I did not see who wrote the judgment below.
Seems to be Lord Justice Haddon Cave, said he defensively. I dare say I agreed with it. Yes, okay, well anyway, thank you, that's helpful.
Can I just put to you the other proposition so that you can answer in relation to, I've asked about set aside. The other point, I mean, and picking up what my Lord Justice Lewison asked you earlier, is that this 9(1)(c we know will be by a High Court judge, and therefore will be at a higher level than either the district judges or circuit judges. And won't that then meet your very proper concerns about separation of powers?
Well, my lord, no, because one still has the Lord Chancellor as a party to that 9(1)(c claim. He has to be a party to it. And we are back to that constitutional quandary.
Well, that's the constitutional point. But but that wasn't an issue in Maza. In Maza, there's these slightly general observations about abuse and so forth and the proper procedure. Underlying those appears to be a concern about collateral challenge. And my lord is putting to you that from that point of view, isn't it enough that even if we're looking at the order of Judge Hellman, it will be being held to have been unlawful by a judge of the High Court?
But my lord, that doesn't address the problem, and this was an issue that was raised in Maza, and it's raised in first instance.
Well, all right, can we just take it one step at a time?
But my lord, the point, the objection to it, is that if you make the Lord Chancellor the defendant to that 9(1)(c claim, which he has to be, then a minister, the Lord Chancellor, is able to agree with a litigant, so to agree with the claimant, that a judge has made an order unlawfully, without that issue ever having to be appealed.
But if there had been, suppose there had been an appeal.
I'm sorry, my lord.
Suppose there had been an appeal. The landlord takes no part in this appeal, and the Lord Chancellor's joined to the appeal. Can the Lord Chancellor not say, I agree, the order was wrong, the appeal should be allowed? Or has he got to fight the appeal?
Well, my lord, in the appeal, and because of this concern, I'll show your lordships in a moment, the Lord Chancellor did not play a part in the Maza appeal. The Lord Chancellor wrote to this court and said, because of my concerns about the constitutional position, I should not be advancing a case between two parties. I'm not a party to this. I was never a party to it. I should not be expressing a view about whether this judicial order was lawful or unlawful.
So you've got an appeal where the respondent really doesn't care one way or the other, doesn't want to be at risk of cost, doesn't do anything, doesn't advance the case, and the Lord Chancellor just sort of sits and waits to see what happens. Is that right?
Yes. And that, the Court of Appeal said that was perfectly proper in the Maza number 2.
That's Maza 2, is it?
My lord, I jumped completely out. I hadn't got to the end of Maza number 1.
I'm sorry to be a nuisance, but look, I understand this point, and I understand this point's important to your case, but am I not right in distinguishing between two different strands to your argument? One about collateral challenge generally, and one about the special constitutional position of the Lord Chancellor.
Yes.
So far as the first strand is concerned, you haven't really answered my Lord Justice Dingemans' point that the collateral challenge problem goes away if the person making the decision is a judge of the High Court, whereas here the challenge is to a decision of the judge of the County Court.
Yes, I would accept that, my lord. I do accept that.
Right.
But my concern, and it's the same concern that was advanced in Maza, for your lordship's note, that's paragraph 50 of the judgment of first instance, paragraph 50 and 51, page 238. If that happens, if that
So sorry, I was just writing down your previous answer. What was the reference you were making, Maza?
Paragraph 50, page 238, says...
Wait. paragraph 200 and
Page 238.
238.
It does run this argument because it says the practical effect of what's suggested is dangerous as it may fundamentally undermine the principle of judicial independence. And towards the end, the submission taken to its logical endpoint would involve a minister being able to agree with a litigant that a judge had made an order unlawful without that issue ever being acknowledged. And then paragraph 51, the Lord Chancellor explicitly acknowledges that this possibility is inimical to the principle to the constitutional concept of separation of powers and the independence of the judiciary. He wants no part of it.
Yeah, that's Lord Justice Ryder.
That's before Lord Justice Ryder, my lord. That same submission was advanced before the Court of Appeal.
And you were going to take us to how the Court of Appeal dealt with it, and you told us in general terms.
Yes, my lord, just in terms to finish the analysis of the Court of Appeal's decision, so back to tab 17. And the court turns to deal with the judgment of Lord Justice Ryder at paragraph 103 onwards, which is at page 307. And we see the conclusion at paragraph 107 about the critical part of the determination is the issue about the declaration, the section 9 of our declaration. And we then see at paragraph 109 and 110 to reject any submissions about judicial immunity, that issue fell away. But 110, where we part company with Lord Justice Ryder, is in particular where he said at paragraph 59 that the only forum in which a claim for damages for a breach of Article 5 can be brought is on appeal in the Court of Appeal. Except for inferior courts or tribunals, the claim could be brought in the High Court. We take the view the same applies to the High Court also. So it's saying if you're seeking to appeal a High Court judge's order and you want to claim damages in respect of that judicial act, you don't have to do that by way of appeal. You still have to appeal it first, but you can bring your damages claim in front of another High Court judge in accordance with the CPR.
Yes?
My lord, we then see at paragraph 113 that the Court of Appeal agreed with Lord Justice Ryder's conclusion that the appropriate remedy is for Mr. Maza to seek to appeal Mr. Justice Mostyn's order, although we don't agree with all of the reasoning. And then at paragraph 116 onwards, the Court considers whether to grant permission to appeal against the underlying order of Mr. Justice Mostyn. And the Court has suggested, as a precautionary measure, that an out-of-time application for permission to appeal should be lodged, and this was done at the start of the second day. And before us, no objection to the grant of permission to appeal was taken by the Lord Chancellor, and either grounds of delay or appeal would have no real prospect of success. And my lord, one then goes on to see paragraph 120. It would be contrary to the interest of justice if an appeal that had a real prospect of success were to find a now only on the ground that the wrong procedure was used. And then there was a submission at paragraph 121 about who should be parties to the appeal. The Court of Appeal made the point that there was still an extant claim for damages against the Lord Chancellor. We see that in paragraph 121. There remains a formal claim for damages against the Lord Chancellor in the particulars of claim. There's been a settlement with the Lord Chancellor. So there's no reason why, in view of the Lord Chancellor's change of position, the damages claim should not be continued against him, in whose favour there has not been any order for a stay. So there's still, this is what's still there. There is an extant damages claim. So what does the Court of Appeal do? They grant the application for permission to appeal against Mr. Justice Mostyn's order, and they stay the damages claim pending the determination of the appeal against Mr. Justice Mostyn's order. my lord, we say that looking at what the Court of Appeal actually did in this case is the clearest possible indication of how they saw the interpretation of Section 9. They didn't say, well, very well, you've got your outstanding damages claim against the Lord Chancellor, why don't you go off and pursue it? You can get your declaration through that route, you can have a court determination of whether there was a breach of Article 5 through that route. What they did was stay that damages claim, grant permission to appeal, so that the appeal court would determine whether the judicial order breached claimant's convention rights, and then the stay on the damages claim would be lifted if the determination had been that there was a breach of Article 5. As it was, the court found there was no breach. So, my lord, if I can take the court briefly, I hope I can do this before the short adjournment, to Maza number 2, which is the decision on the appeal. That's in the next tab in the bundle. Tab 18 judgment starts at page 312. And essentially, my lord, what the appeal court found is that the judge was wrong to make the order that he made, but that there was no breach of Article 5 because there was not a gross and obvious procedural error.
Well, that goes back to something I asked you earlier. Was there a difference between a lawful order and a wrong order? And you said, no, there wasn't, but there can be an order that's wrong without being breached. So an appeal against the original order will set it aside if it's wrong. Doesn't have to be any more than that.
Yes.
So that still leaves open the question whether the order was or wasn't a breach of Article 5.
Well, my lord, it may do. As I say, in most cases, one would expect, if you're complaining about a deprivation of liberty, you were detained unlawfully, you would expect that one of the grounds of appeal would be that there was an unlawful deprivation of my liberty.
Well, it might or might not be.
My lord, in Maza there was. In this case, we say there could have been. The complaint that the claimant had was that he's being detained. Whether he's being detained by the police, whether he's being remanded in custody, that's the whole basis of the complaint that he has and had.
But experience shows that if you're locked up for contempt, most people just want to get out. So sometimes they purge their contempt. Otherwise, they try and set aside and say, I've got no capacity, and if that hasn't worked, they might appeal. And it's only later that they might think, by the way, I would quite like some compensation as well.
But look, that may be the case. But if I'm different, but in the ordinary course of events, I would say if someone is being deprived of liberty pursuant to a court order, one is going to need to say that there's a breach of Article 5 in terms of the court order. But in any event, my lord, what one needs, if it's a lawful court order, one can't ever establish a claim for breach of Article 5, but that is the first stage of any process, a determination that the order is not lawful in domestic law. One can't get a breach of Article 5 without that.
Can I just ask you how your separation of powers point plays with the Lord Chancellor having to decide whether suppose it has just been a normal appeal and they've just said, well, we lack capacity, order shouldn't have been made, and then the Lord Chancellor has to make a decision about gross and obvious error. But how does your separation of powers and constitutional importance point play into that? Because the Lord Chancellor is still having to make the decision.
Well, my lord, he is, but he's not having to make a decision as to whether the Judicial Act was lawful or not. There's already been that determination through the appellate court process. It's been set up to determine that question. So the starting point for any further...
Well, it's a totally different cause of action, in fact, isn't it? Suppose a case which could happen where the judgment, the order is set aside or discharged, quashed from the start because it was said to be wrong. That by itself gives rise to no cause of action. What gives rise to a cause of action is that it was gross and obvious, which will involve a judgment about the conduct of the judge.
My
which
Lord,
the previous
it will.
court won't have made.
They won't necessarily have made that, but the test, and I can show your lordship how it's addressed in Maza number 2, but the test, gross and obvious procedural irregularity, is a legal test. So one is simply applying that legal test to the finding of unlawfulness that the appellate court has already made. So
Well, it would be useful at some point to be reminded, I think it's in LL, but no doubt it's quoted in Mazhar as well, what the test is. I mean, there's a variety of circumstances. Bad faith, obviously very unusual, that could happen. Gross and obvious procedural error, but 2 or 3 others as well.
My lord, I think you can only get a breach of Article 5, an enforceable right to damages under Article 5.5, if there is a gross and obvious procedural error.
Is that right? I'm not saying you're wrong.
No, paragraph 88 of LL, page 214 of the authorities. Will not be lawful if you act without jurisdiction, gross and obvious irregularity, or no proper foundation in law. So there are 2 other subheadings.
But my lord, if the order's got no proper foundation in law, that will be the finding of unlawfulness that you will have in the appellate court. And also if the court acted without jurisdiction. So the only thing that one needs over and above the finding of unlawfulness, in my submission, is that there was a gross and obvious irregularity in the court's procedure.
Yes, I mean, I've never understood Article 5 to be so restricted. If you didn't have jurisdiction, you could get Article 5 damages. Can I
my lord, I accept that. So you can't get Article 5 damages simply because the court order is unlawful, or the court didn't have jurisdiction to make it. The thing that one needs, the additional requirement, is there's a gross and obvious procedural irregularity in the court's procedure. So it's not the case that if this court overturns a decision from the High Court, that it automatically follows there's a breach of Article 5 and therefore there's an enforceable claim to damages. It's got to be more than that.
Can I just finishing off, and I'm sorry to have asked so many questions.
No, sure.
Given the 98 Act was all about bringing rights home, how did the Lord Chancellor deal with the constitutional separation of powers point when he, as it was then, was defending claims before Strasbourg?
My lord, the Lord Chancellor was never defending claims before
The United
Strasbourg.
Kingdom
The UK
was.
government was defending claims before Strasbourg.
And that didn't have a duty to uphold the separation of powers?
Well, my lord, there you have an international treaty. The UK government is a party to that international treaty. So the UK government is the party that is said to have carried out the breach. So that's no different to, say, a claim that you may get in a prison context, a prison assault, one sues the Secretary of State for Justice because he's responsible for prisons. But that's where the government has itself done something. The government is involved in those proceedings. They're a party to those proceedings. The point I'm making about separation of powers and independence of the judiciary only arises because the Lord Chancellor is never involved in those initial proceedings. So in this case, between the social housing provider and the claimant, in Maza, between the NHS Trust and Mr. Maza, the government's never a party to that. The Lord Chancellor's never a party to that.
Thank you.
My lord, we were looking at Maza number 2. If I could ask your lordship, please, to look at page 315. At the top of page 315, this sets out terribly so. So 315 just makes the point under the heading if he was represented. The Lord Chancellor was not present or represented at the hearing. But we see at page 323 how that came about. At paragraph 27. In a letter, the Government Legal Department informed the court that the Lord Chancellor does not wish to advance any submissions as to whether the order under appeal was unlawful. The Lord Chancellor's only role is as a defendant in respect of the state claim for damages under Section 9 of the Human Rights Act. And it was explained in that letter, my lord, why that position was taken, namely the Lord Chancellor's constitutional role. And then, my lord,
You're telling us that because you know you were in the case.
I was in the case, my lord, yes. I have a copy of that letter.
Sorry, you
I have a copy of that letter. I had at some point a copy of that letter. I don't know if I have it right now. And so, my lord, we see underneath what it was the court did. There's no opposition to the appeal at the hearing. For that reason, the court asked the attorney to appoint an advocate to the court. And that is how the opposing arguments were put. That was accepted by the Lord Chancellor's position was accepted by the Court of Appeal. There did not come a letter back saying we would be greatly assisted by the Lord Chancellor's attendance, for instance. So, my lord, what the appeal did was dealt with the appeal against Mr. Justice Mostyn's order, and as part of that, the Court of Appeal considered whether the Judicial Act breached the claimant's Article 5 Convention rights. What they did not do is determine the damages claim. So the analysis, my lord, of whether the Judicial Act breaches Article 5 starts at page 327. Or it starts, the heading starts on 326, but the conclusion, breach of human rights by Judicial Act, starts halfway down page 327.
Yes.
And we see the analysis that's set out. My Lord Justice Dingemans mentioned LL and Lord Chancellor. That's dealt with by the Court of Appeal, paragraph 39.
Yes, and I think, in fact, if we just look at the passage from Lord Justice Jackson's judgment,
Yes.
The 4 points my Lord referred to, I think we gave a shorthand for one of them. It's not just had no proper foundation in law, which by itself might mean almost anything. It's because of a failure to observe a statutory condition precedent.
Yes.
Not quite sure what arbitrary means, but there's some case law about it.
But, my Lord, it's essentially the point in subparagraph 4 there. In considering whether the court's errors amounted to gross and obvious irregularity or flagrant denial of justice, that's what one needs to look at in order to get an enforceable claim for damages under Article 5.5. In LL, it was found that was met. In Maza, the court found that was not met. And, my Lord, we see that at page, the discussion starts at paragraph 51, page 301. There's first a conclusion as to whether the judge's decision was wrong. And then we see at paragraph 61 onwards, that's the conclusion that the decision reached in the case was wrong. And then at paragraph 70.
Sorry, where was that conclusion that it's wrong?
I'm terribly sorry, my Lord. 61, page 334.
Yes.
But the court didn't decide, did it, that there was a breach of Article 5?
The court concluded that there wasn't a breach of Article 5.
Where does that?
So that starts, my Lord, at paragraph page 335.
335.
Yeah.
Well, is that right? This. Oh, I see. 335.
Well, which paragraph are they saying that?
Paragraph 71, my Lord.
71.
Yes, but the structure is up to 70 is all the discussion of whether it was wrong.
Yes.
And that's the ultimate. Although he's already said at 61 it's wrong. Yes. The more reasons are given for that between 61 and 70.
So 71 is saying, is it that there's no breach of Article 5?
Yes. So notwithstanding my criticisms of how the application is made and granted, I am unpersuaded that this court should go further and declare that the errors in this case amounted to a gross and obvious gross and obvious irregularity.
So what use has the appeal served in the claim against the Lord Chancellor?
It is concluded that there was no breach of Article 5. Therefore, my Lord, there can't be a claim for damages under Section 9.3 against the Lord Chancellor because there's no breach of Article 5.
There was a finding of breach of Article 6, wasn't there?
Yes.
There was, my Lord, at that point, that was before the remedial order had amended Section 9.3 to include an enforceable claim for damages under Article 6.
Probably because they realised that otherwise the only remedy is to disappear off to Europe again.
Yes, so that's the Hamilton.
So that was then put right.
Yes, that was then put right after.
Hamilton was. I'm sure you're right. Hamilton preceded this.
Hamilton did, my Lord, but the remedial order takes.
what was the date of the remedial order?
I'm just having a look.
21st of October 2020, according to the notes at page
Yes.
11.
Yes, I see.
Yes, and the Maza action was in 2017, even though the appeal was much later, as I understand it.
Well, the decision was 27th of October 2020.
Yes.
So there may have been transitional provisions which meant it had no effect.
Yeah, my lord, I'll double check over the short adjournment, but I'm almost certain that no damages were ever paid out as a result of this finding. I think because of the point we've just discussed that after
But would Mr. Mazhar then have just said, fine, I've lost here, I'm off to Strasbourg now, I've exhausted my domestic remedies and I've got a finding here in our breach of Article 6? One might have thought he would.
But, my lord, in theory, I suppose he could have done, although if you've got the domestic finding that there's all of these domestic findings, that would make it rather more difficult. But in theory, he could have done. I'm not aware that he has done. My lord, that was what I wanted to show you at Maza. My next heading is just about a few short submissions about the nature of the abuse.
Yes, well, those are obviously better after the adjournment. I mean, it's unsurprising you haven't quite finished this morning. You obviously have more work to do always than the respondent, but you can't go long into the afternoon. How much longer do you expect to be?
My lord, not much longer, because my submissions on the grounds of appeal have, to a large extent, been addressed as I've been going through it. So
Right,
I
well,
will make sure I condense that down over.
Be as brief as you can. Could I just ask your junior to do some work over lunch? It's probably a red herring, but we've been using a lot the term setting aside. No need particularly to get up, Mr. Chancellor. I mean, it doesn't have to be you. Mr. Clement can do it if he wants. And we have been distinguishing it from an appeal. If there was the concept of setting aside is one we've all been brought up with forever, but it presumably has a meaning in the CPR and possibly even in the Senior Courts Act. I don't know. I wouldn't mind just being referred to the provisions that actually give the power to a court to set aside, and ideally the jurisdiction to deal with appeals, what effectively comes out of an appeal. It may be that it's all rather messy, but I wouldn't mind at least having the statutory provisions. Can't promise it'll go anywhere, but it's useful to have them. Well, now, if I say 2:05, is that going to create difficulties? Mr. Westgate, you're not going to be long, are you? I mean, you are going to be long, sorry, but you're not going to be going right up to the wire.
I shouldn't think so, no.
Well,
in fact, I won't.
Well, in that case, let's say 2:05.